Good afternoon. I'm Attorney Terrell Tootin on behalf of the appellant, Regina Sessel et al. I'd ask for 5 minutes rebuttal.
5 minutes, okay?
The case and the facts of this matter is very straightforward. Our brief was very short and to the point on this. I don't believe there's much in dispute. The issue that we have here arises out of the burial of the remains of Regina Sessel's son. So Regina Sessel had a son who was killed and ultimately buried. She entered into a contract with the appellees in this matter, N.J. Ford and Sons Funeral Home, as well as New Park Cemetery. And what she wanted was very simple. She wanted to be able to have her son buried, not cremated, and she wanted to be able to witness him being lowered into the ground, to know that the place that they tell her he's located is in fact where he is. And then she wanted to be able to grieve and heal and get this behind her. Well, the problem with this case is she was not allowed to see the casket lowered into the ground as what she paid for. She was not giving any confirmation whatsoever that he was in fact buried and not cremated. And in fact, when WREG, I believe a news program, had asked for clarification as to what happened, no straight answers were given. So in other words, there was no response of, hey, she's just a little paranoid, there's nothing to see here, there's no concerns. That wasn't what was said. Instead, no clarity was provided. Ms. Sessel and her family is completely distraught and not put at ease. And so what they asked for was something very simple. Show me the remains so that I can put my mind at ease. And the response was, no, we're not going to do that. We're just not going to show you. And so her other position was, well, I received these documents. It makes me believe he was cremated. Can you show me that he wasn't cremated? And I'll go away. I'll walk away. This whole thing will be over.
When you say show me the remains, you mean a request to exhume the body?
Yes.
Okay.
And that has not happened, has been refused to happen, and that's why her case is going forward. Now, the argument being made and why summary judgment appears to have been granted at the trial court level is that the trial court essentially said, and I cite to the record, that the burden would be on Ms. Sessel to show that the body was in fact cremated. And since she couldn't show affirmatively that it was cremated, then essentially summary judgment was granted for at that point, defendants. Well, the problem is Ms. Sessel is the non-moving party. She did not have the burden at that time. In fact, she was entitled to all reasonable inferences in a light most favorable to her. So again, our argument is very straightforward. Nothing, even when we cite to the undisputed facts by the defendants, at no point does any of those undisputed facts lead you to say that the body was not cremated. In fact, they have no affidavits of anyone saying affirmatively it did not happen. And so what we are saying is simply as behalf of the appellants is very straightforward. We don't know what happened. Her mind is not at ease, and someone has to answer this for her, and they're refusing to answer it, and then they were granted summary judgment while refusing to answer that. Now, here's why it's even more problematic. And again, when I say this is extremely straightforward, nowhere, I believe the opposing brief was 61 pages. We could have summed it up in 2 pages and just asked the question, was there contracts between Ms. Sessel and these defendants or appellees at this point? Yes, part of the contract required them to allow her to view the body going into the ground. No one is disputing that never happened. So there, not even at the trial court level, is there any analysis or arguments made as to how that would not be a breach of contract. We included the documents that shows that that was part of the requirements. There's no question that she didn't get that to happen. They're simply arguing, although she didn't see that happen, we are assuring you the body is there. Our position is, even if you're telling us the body is there, once you tell us she didn't see it happen, you've already breached the contract. In addition, now that the contract is breached and she hasn't seen the body go in, she wasn't even given the exact location as to where the body would go, is what we've alleged. She then says, well, then show me the body. because this is what she paid for. She paid for the location, she paid for the casket. You've already, as defendants, did not fulfill your obligations. Then at a minimum, the contract would require them to just show me the body. I'll be done with it. Give me the body, show me the body. That's part of what I paid for. They won't do that. So we don't even have to go down this trail. We can, but we don't have to go down this trail of whether or not the body was in fact or was not cremated before first answering the question of, did she have some type of contractual agreement with the defendants? Yes. Did the agreement require them to allow her to see the body go into the ground? Yes. Did she ever see the body go into the ground? No. After she was not allowed to see the body go into the ground, she said, well, let me see it now. No. When she asked for clarification, was this body cremated or not, because it appears it was cremated, the response is, well, we're not sure what happened, and then really gave her no specificity. So I think our case is very straightforward. I didn't think oral argument was necessary on this, but I believe one of the defendants may have asked for it. But that's all we're asking for. We've shown the contract. If you read their undisputed facts, everything I'm telling you, they don't even touch. You read their brief, there's no contradiction that there was a contract made. There's no contradiction that the contract was brief. So now I'm perplexed as them, what are we here arguing? I honestly don't know. And so I'd ask that the ruling of the trial court be reversed. And unless there's any questions, I mean, I think this is really straightforward.
Thank you.
Thank you.
Good afternoon. I'm Al McLean with Spicer Rudstrom here on behalf of the joint appellees. The case that was just recited by opposing counsel is not the same case that I'm working with. He mentions a contract. There were two contracts, a contract with N.J. Ford and Sons Funeral Home, a contract with New Park Cemetery. Neither of those contracts say what he says they say. Neither one says that they will ensure or provide the plaintiff the right to see the body lowered into the grave. There's no such provision in either one of these contracts. But to back up, to go through the issues in order, the bottom line is that the plaintiff's complaint is hinged on the assertion that the body was not buried in New Park Cemetery, but was cremated. But there's no proof of either one of those two things. The proof is that the body was buried in New Park Cemetery. There's the death certificate, which was part of the record, that shows clearly on it that the body was buried in New Park Cemetery. The only thing that the plaintiff has asserted and submitted to try to show that the body was cremated is a medical examiner's report that was prepared by the medical examiner, not the funeral home, the report was prepared by the medical examiner, not by the funeral home or the cemetery. And in that report, there's a box where it has something about cremation approved, and that box is checked yes. Well, the deposition of the medical examiner was taken, and that's part of the record in this case. And in that deposition, it's made clear that all that box means is that as far as the medical examiner is concerned, it was okay to cremate the body, that they were through with their examination. And it does not mean, in his deposition, the medical examiner testified that it does not authorize the funeral home or the cemetery to cremate the body unless the family so desired. So there's no doubt that that's what those documents mean. The plaintiff has presented no other documents that support the theories that they're asserting. So we would submit that based on the documents that were presented to the court, which were undisputed, the contracts, the death certificate, the medical examiner's report, the deposition of the medical examiner, and the deposition of the plaintiff, Ms. Sessel, that there's no dispute about the facts. The fact is that there's just no proof that there was any breach of either contract that the plaintiff entered into. The plaintiff asserts in this court, did not assert in the trial court, that there's a provision in the contract with N.J. Fort and Sons Funeral Home that includes a line item which is called, quote, use of facilities and staff for viewing/visitation, close quote. And the plaintiff asserts that that provision is the provision that requires the N.J. Fort Son Funeral Home, not the cemetery, but the N.J. Fort Son Funeral Home, to make sure that the plaintiff could watch the body lowered into the grave. Well, that phrase is known to mean that the facilities and the staff is provided for viewing at the funeral service, which was done, and there's no dispute about that. Mrs. Sessel's deposition makes it clear that she saw the body in the casket at the funeral service. It was an open casket service. She saw the body. She doesn't dispute that. She also followed she went in the hearse with the body that was then closed and taken to the cemetery. She was there. She watched that be done. She went to the cemetery, watched the casketed body being laid at a place in a gazebo where they have the committal service, and that's where the casketed body was. There's also proof in the record that shows that Ms. Sessel was advised that the body was not going to be buried at that moment, right after the committal service, because it was below freezing and they couldn't dig a hole. So there was no issue at that point in time about anything. It's only a year and a half or so later that Ms. Sessel gets a copy of the medical examiner's report and sees that box check cremation approved, and she assumes falsely that that means the body was cremated. But there's no proof of that. And plaintiff's counsel argues that there was a burden on the part of a burden of proof on the part of the defendants to disprove what he's saying, which is not the standard. The standard is the moving parties, which would be us, have the burden of production, which means we had the burden of producing some proof that shows that the plaintiffs cannot establish all the elements in their claim. We did that. We submitted the proof. We submitted the proof that showed the body was buried in New Park Cemetery. Showed proof that the medical examiner says, no, this does not mean the body was cremated. They presented no proof to the contrary.
I understand you have got affidavits and that the casket was taken to the cemetery, was placed on a gazebo. Do you have any proof that the body was actually buried?
We do not have proof of that. Well, I mean, we have not submitted any affidavit to that effect. But there's no proof to the contrary. There's just none.
Well, if that's the case, don't we have a lingering issue there? We know that the body was delivered to the cemetery, was placed on a gazebo,
Right.
And that's sort of where the story ends as far as the proof is concerned.
The proof includes the death certificate that shows the body was buried in New Park Cemetery. So there's that proof.
Well, that's correct. I stand corrected on that.
So they have not countered that. And there's no proof that the body wasn't buried there. It was just, there's none. So we would submit that
What about the contracts? Are the contracts between the two defendants in the record?
they are, Your Honor, and I have copies of them here, but they are in the record.
In your legal opinion, which contract requires which defendant to actually provide the burial services?
That would be the New Park Cemetery.
Okay.
But neither contract has what Mr. Tootin says it has in it, which was that there was a right to see the body lowered into the grave. Neither one of these contracts have that provision in it. So he made that statement. I have to make that point. As far as the correct legal standard, what the judge, trial court, did was applied the Rye versus Women's Care Center standard. And in fact, she quoted it in her ruling. She stated that she was going to apply the Rye standard, which plaintiff's counsel says was erroneous But she stated in her ruling, quote, "When the moving party does not bear the burden of proof at trial, the moving party may satisfy its burden of production either by affirmatively negating an essential element of the non-moving party's claim or by demonstrating that the non-moving party's evidence at the summary judgment stage is insufficient to establish the non-moving party's claim or defense." And that is what the RISE standard calls for. And there were no inferences to be drawn from the facts that would be supportive of the plaintiff's claim. There's no inference from the fact that the death certificate shows that the body was buried in New Park Cemetery. There's no inference there that supports it. In fact, that's proof to the contrary of the plaintiff's claim. There's no inference from the medical examiner's report just because it has a box check cremation approved when you have the testimony, sworn testimony of the medical examiner saying that does not authorize cremation. That is just an authorization that it can be cremated if the family so desires. So there's no proof that the plaintiff has presented to show that there was any issue of material fact. The appellant also, well, I'll strike that, I've already covered that. Also, the plaintiff's brief misconstrues the ruling of the trial court as to the claims of the minors. The trial court ruled in the case that both the claim of the adult plaintiff, Ms. Sessel, and the claims of the minors were failed because of the lack of proof of the essential elements of their claims, which were, number one, their claim that the body was cremated and not buried. They didn't prove that. They didn't offer any proof of that. And number two, that there was a breach of contract by the two defendants, and there was no proof of breach of contract. As far as an exhumation of the body, the record shows that Ms. Sessel never requested exhumation of the body. She could have if she wanted to. In fact, that was offered to her. If she wanted to exhume the body, the cemetery was willing to do that. But she never made that request. There was no request that the body be exhumed. So that was the burden, or not the burden, but the right of the plaintiff to have the body exhumed if they wanted to. But she didn't do that. And then also, we would submit that the brief submitted by the plaintiffs is woefully deficient in terms of setting forth an argument and facts that support their argument. And we raised that issue in our Appellee's brief, and plaintiffs have not filed a reply brief countering that issue or addressing that issue. And we would submit that they have waived the argument that they have not adequately prepared or submitted a brief under Rule 27 of the Tennessee Rules of Appellate Procedure.
What about the statute of limitations?
That's also, the statute of limitations is the other issue we raised, we argued in our brief that we submitted that the plaintiffs did not present in their brief any cogent argument on the statute of limitations. They didn't even argue that the statute of limitations barred Ms. Sessel's claim. They just vaguely said that the minors' claims were not barred by the statute of limitations. And we would submit that they have waived any argument about the statute of limitations just because of the lack of any cogent argument in their brief. There's a 15-line paragraph that addresses statute of limitations, which is basically a summary conclusion, but no actual logical argument as to why the statute of limitations doesn't bar Ms. Sessel's claim. As to the issue of the minors' claims, we also raised in our brief an additional issue which was not addressed because there was no reply brief filed, and that issue is the lack of standing of the minors to assert a claim. And we have argued in our brief that under Tennessee case law and the Tennessee statute that governs the priority of who has the right to control disposition of the body, that it's clear that a minor does not have a right to control the disposition of a body. And it's also clear under Tennessee case law that only the person who has the right to control disposition of the body has a claim that's based on mishandling of a deceased body. We quoted or cited the case in there that holds that, which is Akers versus Buckner Rush Enterprises, 270 Southwest 3rd, 67 at page 72. And then we cited the statute 62-5-703 that provides the list of persons in order of priority who have the right to control disposition of the body of a decedent, and it clearly does not include minor children. It provides, quote, "The right to control disposition of the decedent's remains vests in the following persons in the order named, providing that such person is a qualified adult." And then it lists the priority. And Ms. Sessel is number 4 on the list, but she was the next of kin under that list. So she had the right to control disposition of the body. The plaintiffs, the minor children did not. And so we would submit that under Tennessee case law and Tennessee statute that the minors have no standing to assert their claims. And it could be, on the other side, they might argue that that issue was not raised in the trial court, which it was not. However, we've submitted a case, the state of Smallman, 398 Southwest 3rd, 134, at page 149, Tennessee Supreme Court case in 2013 that held that although standing was not raised at trial, at the trial court level, the court could consider the issue on appeal since it involved the issue of standing that's based on a statute. And we submit that this issue of standing is based on the statute, and therefore the children's claims, they don't have standing to pursue. So we would submit that for all of these reasons, the trial court's judgments, granting summary judgment to the defendants, should be affirmed. And that's all I have. If you have any questions for me, for anybody? Okay.
I don't see any.
Great.
Thank you.
Appreciate it.
See, did you request rebuttal time?
Yes.
Okay.
So hearing opposing counsel's arguments about not being aware of the arguments I'm making or something to the effect of this is his first time hearing or understanding the arguments, that's unfortunate for opposing counsel because these arguments exist all throughout the record. So first, this representation, I would have loved a citation of anywhere on earth, let alone the record, where there was an offer to exhume the body and that Regina had a right to that. We believe she had a right to that. We're saying the primary reason we're here is because there was a refusal to do that. If opposing counsel is asserting otherwise, that of all the things he wanted to cite to, there was no citation to that because that simply is not accurate. There was no offer to exhume the body. As you may be getting a gist of the tone and the type of the arguments are being made on behalf of the appellants, it'd be very clear that if they seen the body and was able to get that type of relief, we wouldn't even be here right now. This is not about more, it's less about money and more about that body. So if that is truly what opposing counsel believes, I would have loved a citation to anywhere on earth, let alone the record. As far as not knowing these arguments existed or hadn't seen them before, I could just direct everyone back to the complaint, actually. So in volume 1, paragraph 18, talks about, prior to that, number 17, it talks about how funeral was conducted. Number 18, it talks about defendants required plaintiffs to leave and she was not allowed to witness the body being buried. Goes on to number 19, talks again how she wasn't, plaintiff was never informed as to why she couldn't witness the body. Goes on to 22, and keep in mind, this is a complaint. This is the only complaint that was filed. So this existed as long as the case existed. So if this stuff that I'm saying is news to opposing counsel, again, that's unfortunate. But again, number 22, also in the complaint, I won't read it all to you, talks about this issue. Number 23 also talks about it. I'll now pivot over to the death certificate because I don't believe that was an argument that was accurate. The death certificate, I believe, is page 154, talks about how the appellants didn't attack it, there being a burial, and even the death certificate says that. The death certificate was signed and dated January 1st of 2017. All of this happened afterwards. So the death certificate is essentially saying, here's the cause of death, here's what we're being told on this death certificate is how the body will be handled. It'll be handled by burial. This is where we're told it will be handled. and you check the box and you put the address. The death certificate is not saying this in fact happened and I'm vouching for it, and opposing counsel, I'm sure, is aware of that. So to make the argument that they didn't even attack the death certificate, we agree what was supposed to happen. What we're saying, and I believe the questions were asked and adequately so, is is there any record of anyone anywhere saying, I know for a fact the body actually went in the ground and I'm making that representation? No. That representation to this moment has never been made. So now let's pivot to this other issue about, well, Mr. Tootin, nowhere in the contract does it talk about being able to view or see the body going in. And then conveniently, he cites to where the contract talks about it with N.J. Ford. That's page 180 in the document, where it talks about viewing and visitation. But what he tells us is that his argument is he's going to fill in those blanks and tell us verbally here today now that what that really meant is that it can just be viewed at the off-site, but not necessarily at the grave site, and then provides us nothing other than his word on that. That contract does not say that. He simply says that. Well, the problem is you have to review this in the light most favorable to Ms. Sessel. So not only does Ms. Sessel herself say that that's what she had contracted for, not only does Ms. Sessel say herself that that's what she was entitled to, but then there's a contract that supports that position, especially in the light most favorable to her. If you're saying we have to fill in the blanks with arguments being made now by opposing counsel or myself, then that's even more of a reason to say summary judgment being granted was premature, because the only blanks that can be filled in, we probably need a trial on that matter. And then lastly, I'll say, to save any time, I'm unaware, I don't believe, as he said, they raised the issue about the children having standing. Our concern primarily is this body. If the court feels to address standing on the children, I mean, we're going to end up in the same spot. We wanted to name as many possible plaintiffs as possible so that nothing slipped through the cracks. We, to the extent it's even necessary to say we have no concern, we consent, we agree to the court dealing with standing as it relates to the minor children, because we have what they say, bigger fish to fry. We're trying to figure out what happened with this body and to give this family peace, and we don't care if it has to be the children to make this issue or Ms. Sessel. That's where our concern is. We have no issue with addressing the children on standing or whatever the case may be, or concluding they don't have any. That's the least of our concerns with the issues we're raising. Thank you.
Thank you. Thank you both. Would you call the next case, please?